All right. The young lady in Division 1, 6th floor, can you tell me your name? The person in Division 1, miss, can you tell me your name? Yep. Oh, you're still, there we go. Try it now.
Mariah Bush.
All right, this is State of Michigan versus Mariah Bush, case 24058713101. Today is the date set for a bond redetermination hearing. Bond is set intentionally unaffordable in this matter. Appearances, please.
Lisa Coyle, appearing on behalf of the people.
Your Honor, Philip Reagan on behalf of Mariah Bush, who is here for bond redetermination hearing, Your Honor.
All right, thank you both. Good morning, Miss Bush. Mr. Reagan has the bond.
Judge, Miss Bush's bond was set a $10,000 cash assured bond, no alcohol, no illegal substances, GPS testing. Your Honor, I would point out that my client, doesn't have any assaultive history. It's my understanding.
Excuse me, Judge.
Hey, Mr. Reagan, I'm sorry. There's something wrong with your background. There's just a lot of noise back there, and it's not coming through.
It's quiet over on this end, Judge.
Well, let me try to mute Miss Bush. That might help. I'm sorry, Mr. Reagan. You can continue.
You're fine, Judge. Judge, I would point out that I do know the 2018 fraud case with my client completed probation, Judge. I'm trying. I think there might be a previous drinking case. Now, I would point out in this case, Judge, I don't believe the blood alcohol level. There are no test results that have come back yet on this case. She is not working at the present time, Judge. She does have one son. I'm actually requesting, Judge, a personal bond. I think that the court could use a less intrusive measure than actually a cash bond to ensure with no driving, no alcohol, whatever other conditions the court wanted to impose. But obviously, Judge, I am asking, and again, this is a bond hearing, Judge. We're not, to try our facts to determine whether something's happened or not. We're just asking the court to consider bond in this particular case. And I think the court could do a personal bond with whatever conditions the court wanted to ensure that Ms. Bush did not drink, does not drive. So I'm asking the court for that at this time, Judge.
All right, thank you, Mr. Reagan. Ms. Coyle has the bond.
Your Honor, I do see 2023 out of Fraser District Court 39B. She pled guilty to operating while impaired. Her high BAC was dismissed. She received a probationary sentence. Also, out of the 47th District Court, which is Farmington, there's a bench warrant for a failure to appear on a disturbing the peace probation violation. And the lien says no bond. She had pled guilty under HIDA status. She received probation. This case occurred at about 4:05 in the morning. As the court can see, she and her infant child were in the car. She crashed into a guardrail. She refused to provide her name to the officers. She refused to perform field sobriety tests. She cursed at the officers. She resisted cuffing. She bit the officer's arm, broke the skin. That's why she's charged with the R&O injury. This is a felony. She then had to force her down to the ground to cuff her. They ran the lien on her license plate. It was a false license plate. Your Honor, based on all these things, the blood results are pending, likely will show that she was operating over the legal limit of 0.08. Your Honor, based on all these facts, that she has a failure to appear right now. She has a prior OWI. She made the mistake of getting behind the wheel of a car when she was drinking. Not only that, she placed her infant in that car, and then she did crash that vehicle. So she is a danger to the community because she put her own child at risk. and caused an accident, which could have been way more detrimental. Your Honor, I'm asking for that cash bond to remain in place, a tether, as well as the alcohol tether, because obviously she knows she's not supposed to drink and drive and she can't control herself. And so in this way, we're asking for the cash bond because she cannot use common sense and not to get behind the wheel of the car, especially with her child in the car, and drive a vehicle.
1 second. All right, I've had a chance to review the investigator's report as well as figuring out what's going, figuring out what is, hearing the arguments and figuring out what was going on in Frazier. It looks like the defendant pled guilty to operating a motor vehicle while visibly impaired back in January of 2023, and that probation has been completed. The defendant is not on probation or parole at this time. And I have to determine whether Ms. Bush is a danger to the community that needs a high cash bond as the only means to make sure that that happens, or the presumptive release pending the terms of this hearing. I do believe that there is clear and convincing evidence that Mrs. Bush poses a danger to the community based on her actions or her alleged actions in this matter, as well as her past action, her past record. I don't believe that there are least restrictive means outside of a tether, strike that outside of a cash bond in this matter. So bond is going to remain the same. Ms. Bush, your next date is
August 30th, Your Honor.
August 30th, 2024, before Judge Sabri. Today is the date set for a bond redetermination hearing. Appearances, please.
Lisa Coyle appearing on behalf of the people.
So Reagan, on behalf of Mr. Bradshaw, Your Honor, who's here for bond redetermination.
All right, today is the date set for the redetermination hearing. Bond is set intentionally unaffordable. Mr. Reagan Esteban.
Can you give me 10 seconds, Judge? I apologize, of course.
Sure.
It's even worse than the bomb. It's worse than the bomb. But I didn't do it, so I came back. Because I'm briefly from South Carolina. In South Carolina, in Holland, we got the first one to the car like it's snow. I didn't have no out in the I'm up here to go. We go through there. Don't touch my face. Like a little breeze of snow.
Oh, excuse me.
Somebody thought they will be in my, you know, my teeth or whatever it says.
All right, I'm sorry, Judge. I apologize. Okay. One of the things I wanted to look at, anytime there's a domestic relationship, I try to get a better understanding. Her bond is 100,000 cash. You know, my client works at America Park, but she is on probation for embezzlement. She's on probation for embezzlement, not assault. And now, you know, when I read the investigator's report, Judge, you know, it kind of reads a little, I don't know the word, Judge, but it's a little disturbing. But now I would note that there have been four prior cases of alleged DV. Mr. Latham has refused to prosecute in the past. You know, I think it says here he wants to go forward. I know they, you know, have been on and off. You know, what I'm asking the court to do, obviously no contact, GPS tether, house arrest, you know, I'm asking for a reduction, Judge, to personal, but I'm asking for those conditions. I think no contact. I think she needs to sit in the house. She can't go to Comerica. Season's almost done. She can't work anymore. She's got to sit in the house. And I'm saying this just because I don't want to be a trial fact here. I don't want to determine, you know, what I'm reading in the hearsay document to take it as true, because it's always a lot more to it. But yeah, based on what I'm reading, I think staying at home is important. You know, so I'm asking for a reduction with the condition of house arrest, GPS tether, maybe two tests, GPS tether, and yeah, she can't go out the house. So I'm asking for a reduction to a personal bond.
All right, thank you, Mr. Reagan. Ms. Coyle has the bond.
As to her criminal history, I do see a 2017 larceny in a building, and she is on probation, as Mr. Reagan said, the Sixth Circuit for embezzlement. On her lien, there were several identification numbers: California, Washington, Michigan, Ohio, which listed, it's so long to even list how many cases that there were based out of all these states, and including bail jumping. But with that in mind, Your Honor, this standing on itself is extremely disturbing in the sense that, and shows that she's not only a danger to the complainant in this matter, but to the community, in that she's so nonchalant about her actions. Officers did observe and smell the odor of gas. They also noted the cut to the complainant's eye. They observed the video in which the defendant had a gas can in her hand, splashing the gas on the car. The video also shows the defendant punching the complainant, shows her setting the car on fire with him in it. The defendant's statement that she admits to grabbing the gas can, to pouring the gas and lighting it. And when asked, she said, he probably would have died. He would have burned up, but I wouldn't let him die. I would have tried to put him out. That's frightening. I also noted in the investigator's report, there were DV complaints between the two of them from 2021, where the complainant was the victim and he refused to prosecute. And in 2023 and 24, there were three reports that the complainant is the defendant, but she then didn't follow through. So this is a very volatile situation. This is a situation which could have caused more than just damage to property, as well as she's pouring gas on his body, soaking his clothes and assaulting him with, she had, if I recall, keys in her hand when she struck him. Your Honor, the evidence is very strong. It's on video. There's evidence of the burning. She also confessed to this. She is a danger to the complaint and to the and also a potential flight risk. And she is on probation and for 3 years. So she knows she's not supposed to be doing anything assaultive. So based on all that, Your Honor, I think the bond is appropriate considering the nature of the offense, as well as all the other bond conditions.
I agree. The allegations in this matter are beyond disturbing. But I believe that, this creates a situation where I believe that there is clear and convincing evidence that this person is a danger to the community. Not only pouring gasoline on, the piece of property, but on someone, and then, igniting, shows me, and these are allegations. I don't know exactly what happened. But I don't trust this person right now, and I don't believe that anything outside of a cash bond can be used to make sure that this doesn't happen while this matter is pending.